Welcome to VEROSCOPE. Today we're going to be analysing the case of Jennifer McCabe's trial testimony. And this is in the trial of Karen Reid, the Commonwealth versus the Karen Reid. If you're from the UK and perhaps you haven't heard of this case before, this is John O'Keefe, who was found killed on the lawn of a fellow police officer in Boston. And his girlfriend at the time, Karen Reid, is the defendant, and the judge is this lady, Judge Beverley Cannone, and the prosecutor is this chap called Hank Brennan, who was also the lawyer for a mobster called Whitey Bulger. So he's a mob lawyer. Good lawyer in the sense that he knows all the tricks. And if you're a gangster, perhaps the chap that you want to represent you. But in this trial, what we're going to see is him use these techniques to his advantage, and potentially, and in my opinion, the judge being slightly biased in support of that goal. And this particular analysis, which we're going to be doing, is going to demonstrate how Hank Brennan is concerned that the defense attorney, Alan Jackson, is going to expose this lady, Jennifer McCabe's first trial testimony as being different than the second trial testimony, and hence hurt her credibility on the stand. And so the jury would then weigh up any other evidence that she gave with that in mind. So the prosecutor wants to do all that he can to prevent the jury hearing this discrepancy in her two testimonies. The first trial ended up as a mistrial. This is the second trial. So Alan Jackson's job is to show that she's changed her testimony, and that would reduce her credibility on the stand. Let's listen to it from here.
Over to assist Ms. Reid in giving first aid to, at least initially, to Mr. O'Keefe. Is that right?
No, that is not. Carrie got out and walked over, and then I got out and walked over.
Just before we go on, thank you so much to everybody. This is a young channel, only weeks old, and we've had a lot of support, over 3,000 subscribers so far. So thank you so much, and also tremendous comments, many of which you've asked me to analyze different cases. And this is an example of one of them, the Karen Reid trial. And I've also been asked to do analysis of 7 other cases where some of which are missing children, others are murder trials, and they're all on the list. And also we need to complete the Jennifer Soto examinations and also the Stern prison calls, which people have asked me to analyze as well. They're all in a list, and I'm hoping in the next 2 weeks they should all be up with the analysis. So if this isn't the one that you've asked for, apologies, but there's still a lot to learn within it. Okay, let's carry on.
Indicated that well, let me ask a different question. Yesterday, you testified in pretty significant detail that when you got out of the car, you could not see anything even close to the flagpole, correct?
Visibility was very bad, yes.
Matter of fact, you used the word whiteout conditions. Is that right?
Yes, I did.
Whiteout conditions, you basically can't see your hand in front of your face.
I wouldn't say that extreme, but I used whiteout as there's just snow coming at you.
You were specifically asked by Mr. Brennan, how close did you have to get before you could actually see anything of note where Ms. Reid had gone? Is that right?
Yes.
You testified yesterday that you could see just merely shadowy figures.
So she has a habit of looking at the jury when she answers and then nodding to back up and give more weight and credibility to whichever answer she gives.
Of Ms. Reid and Carrie Roberts, and it wasn't until you got very close over to them that you could.
And something else to look out for is she also has a habit She's an intelligent lady, this lady. She knows full well what Jackson is attempting to do, attempting to demonstrate the differences in her testimonies. And she looks to her right-hand side once the pressure builds, and in my opinion, she's looking to the prosecutor to either object or use one of his other techniques or tricks.
See John, in your words.
Correct.
As a matter of fact, you followed that up by saying that that was the first moment, once you got basically on top of them, that was the first moment that you realized that it was John, that there was a body on the ground, correct?
I said as I got close to them, I don't think on top of them.
Fair enough. It's my words, not yours. You did say, quote,
Boom. Did you see that? That was the first look. That was the first look for help. That was almost telling him off. Why didn't you object? And she had to use the almost gaslighting technique to be really picky with the words. But fair enough, as Jackson will tell her later, words are important. So fair enough. And Jackson admitted that and said, fair enough, they were my words.
very close to them, correct?
I'd have to see it.
Boom, did it
Well, you
again.
just testified to it yesterday. If you remember saying, I get very close to them.
I know I said I had got very close to them or close to them, something like that,
Okay.
yes. Mm-hmm.
I don't have a transcript of yesterday's testimony, I'm sorry.
See that little smirk there? She couldn't help that. Let's have a look at the testimony so far. So Alan Jackson says to assist Miss Reed in giving first aid to, at least initially, to Mr. O'Keefe. Is that right? So the scene is this. They've come across John's body lying in the snow on the lawn, and Karen Reed, assuming that he's cold and has hypothermia, can't see that he's breathing, but potentially in the cold, the breath can become extremely shallow, and also the cold can be life-saving. So she's attempting to provide life-saving treatment for hypothermia, exposing his skin, getting body on body, helping. McCabe says, no, that is not. This should be Kerry, so it's a spelling error. Got out and walked over, and then I got out and walked over. Jackson. You indicated that. Well, let me ask a different question. Yesterday, you testified in pretty significant detail that when you got out of the car, you could not see anything, even close to the flagpole, correct? And she says, visibility was very bad, yes. Matter of fact, says Jackson, you used the word whiteout conditions, is that right? McCabe, yes, I did. Truthful. Jackson, whiteout conditions. You basically can't see your hand in front of your face. McCabe, I wouldn't say that extreme, but I used whiteout as there's just snow coming at you. So here we are. McCabe confirms the term whiteout conditions, a meteorological term meaning visibility near zero. Helicopter pilots, they'll let you know that's true. She attempts to walk back from the extremity, but confirms the phrase. This establishes the impossibility baseline. She claims visibility in the first trial so poor that she could not see anything. And in the first trial, she claims that she could see everything. So here's what Jackson's trying to prove. A difference in the testimony. Highly important in a murder trial, that he can show this witness's credibility is not strong. So let's go back to the actual video. See that smirk here?
Last year you testified to something very different than that, though, didn't you?
No.
Isn't it true that last
Interesting. So she thought of saying something and changed her mind and remembered her coaching.
year you testified that...
Look at the look. She gave Brennan a help me look. This is not usual. The prosecutor and the witness, as far as, in my opinion, there's a line being crossed. more than coaching. We're now looking at prosecutor. We're now looking at help from the prosecutor, in my opinion.
You got out on the passenger side of the vehicle, which is, we'll agree, the furthest side from the lawn, as Miss Roberts was driving from Chapman toward Crestview. Is that, Cedar Crest, correct?
There's that little smirk again and the little look towards Brennan for help. She knows that if this comes out clearly, the jury will see that it's clearly discrepancies in the two trial statements.
Yes.
You testified that you were on the passenger side, and as you got out of the vehicle, you noted that Karen Reed was already at John. Is that right?
As I got out and walked around the back of the vehicle, the shadowy figure of Karen had already gotten onto something.
I wonder who came up with the phrase, the shadowy figure.
You further testified that as you got out of the vehicle, you noted that she straddled John, lifted up his shirt, lifted up her shirt, and went to lay on him. And Miss Roberts went over.
She can't. She's panicking inside her head that she's going to be exposed for having different testimonies. She's constantly looking at Brennan for support. Brennan, unfortunately, can't find something to object about.
Said she started removing snow from John's face. Correct?
I have the page and line number.
The look came across. Help me, help me, help me. This is now the fourth time she's given the look. He comes out with a very creative way. Let's listen to that again.
And she started removing snow from John's face. Correct?
I have the page and line number. Did
you see that? Did you catch it? It's worthwhile looking at one more time, and then we'll listen to Brennan's creative way to disrupt. One of the tactics that you can use in a trial is to disrupt and disturb and stop the flow and get everything confusing and ask the question to be repeated. And this is skilled strategy to prevent testimony being heard and prevent the jury hearing it clearly. And I believe, in my opinion, this is what is being employed at a very high skill level. And you have to know what's going on to see it.
Where are you,
Sure.
Mr. Jackson?
May 17, 2024, RT.
And this is the tactic that was, this was the tactic that was used. This was the tactic that was used. The "excuse me, miss, where are we" tactic. So he couldn't object because there was no real legal objection. So up his little sleeve is the "excuse me, miss, where are we?"
Shirt, and went to lay on him. And Miss Roberts went over.
There's the look.
And said she started removing snow from John's face. Correct?
There's the look again.
Page and line number.
Where are you,
Sure.
Mr. Jackson?
And the judge jumps in to help as well. Where the speed, where's the page and line number? And then unbelievable.
May 17, 2024, RT.
I'm angry because I know these tactics. And when you see them employed blatantly, to the jury and to most people, you wouldn't recognize them necessarily. But once you know them, you know them. And now that you know it, you'll see it again and again and again in other trials.
114, lines 14 to bottom, onto 115, line 4. Is that how you testified last year?
I'm sorry, would you mind just repeating it?
Sure.
Boom. That's coached, because that's an excellent way to create more and more confusion.
Thank you.
You testified in substance that you were on the passenger side of the vehicle, and as you got out, quote, "as I got out," end quote, she, Miss Reed, was already at John. You indicated that you saw her straddle him, lift up his shirt, lift up her shirt, and lay on top of him while Miss Roberts went over and removed snow from his face. That's how you testified last year, correct?
Exactly.
So she looked before the object. Did you see? We have coordination between the prosecutor and the witness, in my opinion.
Is that how you testify
She looks at the judge, and then the judge asks a question.
last year?
I'm not sure. I know
Next question.
Would it,
She says, I'm not sure I know, and is about to dig herself a great big hole. The judge gets her out of it, doesn't let her finish the question, doesn't let her finish her answer, rather, and then essentially cuts her off and says, next question.
Is that how you testified last year?
I'm not sure. I know
Next question.
would it refresh your recollection if you were to look at a copy of your testimony from last year?
I don't think looking at it would refresh my memory. I know I might have used different words, but the bottom line is I got out of the car, went
Okay, so now she admits that she's minimizing. She admits that she used different words. In other words, another way of saying the same thing, and Jackson will try to prove this, is it's not just using different words, it's different testimony entirely.
behind the car, went over, and Karen had done that.
Ms. McCabe, I'm asking, do you think it would refresh your, if you don't have a good recollection of how you testified last year on your oath, sitting on that witness stand? I'm asking, do you think it would refresh your recollection to see your transcript from last year?
I don't need to see my transcript. I know what I know and I know what I remember. So
That's not my question. I'm not asking what you remember now. I'm asking how you testified a year ago, ma'am.
whether I said it was as we're fighting over silly words, whether I said it's
You're not fighting over silly words, you're fighting over one testimony being entirely different than the other testimony. Let's look at this in some more detail. So, Jackson, you testified yesterday that you could see just merely shadowy figures or of Miss Reed and Kerry Roberts, and it wasn't until you got very close over to them that you could see John in your words, correct? McCabe then goes on to say, as a transcript error, as I said, I got close to them. I don't think on top of them. Fair enough. It's my words, not yours. You did say, quote, very close to them, correct? And she says about the transcripts, I'd have to see it, but well, you just testified to it yesterday. If you remember saying, I get very close to them. And Jennifer says that she knows that I said I had got very close to them or close to them, something like that, yes. And so here for those who have seen the previous videos, we're starting to see fractures, we're starting to see deceptive language. McCabe confirms all of this, and Jackson says, I don't have a transcript of yesterday's testimony. I'm sorry. Do you remember? Then this is where she smirks. Last year, you testified to something very different than that, though, didn't you? And then she thinks, and she says, no. And then Jackson says, isn't it true that last year you testified that you got out on the passenger side of the vehicle, which is, we'll agree, the furthest side from the lawn, as Miss Roberts was driving toward from Chapman, Crestview rather. And she says yes. And then Jackson says, you testified that you were on the passenger side and that you got out of the vehicle. And you noted that Karen Reed was already at John, is that right? And McCabe says, as I got out and walked around the back of the vehicle, the shadowy figure. This is fascinating. I would really love to know who introduced this phrase. It's not normal language, is it? But we know what it's painting. of Karen had already gotten onto something. So, Jackson, you further testified as you got out of the vehicle. You noted that she straddled John, lifted his shirt, lifted up her shirt, and went to lay on it. And Miss Roberts went over and said she started removing snow from John's face, correct? And then McCabe's talking about the page number and the line number because the transcript hasn't picked it up. But we remember hearing Brennan come in with, "Excuse me, miss, I've lost my place," because he can't object. So that's one of his tricks. This, again, in my opinion, is a coached technique. Used strategically when you're in a bit of trouble, you can just say, "I'm sorry, can you repeat that for me, please?" Leaving the defense attorney with little option than to repeat it. And if you do this enough, confusion occurs. It's tactics. But here's the thing. These tactics are only employed when you're not telling the truth. Truthful witness statements don't need all of this shenanigans. So Jackson says, "Sure, thank you. You testified in substance that you were on the passenger side of the vehicle and you got out, quote, as I got out, end quote. She, Miss Reed, was already at John. Is that how you testified last year?" Now she says, "I'm not sure. I know," and the judge interferes. Let's go back to the actual testimony itself.
As I got out of the car, we were there.
Words matter. They matter a lot.
Okay, so remember, Mr. Jackson, no comments. Ms. McCabe, try and answer his questions.
Okay.
Do you remember exactly how it is that you testified last year?
I do not know.
May I approach?
Yes.
Thank you.
Okay, so she's now going to look at what she said last year, and you can imagine what's going through her brain. She's desperately trying to think of reasons as to why the two testimonies are different. It's very subtle, this part of the trial. It's difficult to analyze, especially with poor transcripts, so I do apologize for that. As you can tell, it's made me very angry because it's so blatant. You're going to have to look up at some point. You can't just keep hiding.
May I, Your Honor?
Yes.
Thank you. Ms. McCabe, does that refresh your recollection as to how you testified in substance last year?
I see what it says, I said, but it's a little bit different than what you stated.
Okay, then let's walk through that.
Okay, so that's a coach tactic as well.
Did you indicate last year that as you got out of the vehicle, that's when you could see what Miss Reed was doing with John O'Keefe?
Did you see the look? It's clear as day.
Down to the detail of pulling her shirt up and pulling his shirt up to try to go skin to skin.
And again, this is the prosecution and McCabe coordinating, and she's asking for help. They're exposing the fact that she has got two testimonies, one in one trial and this one. And if it's exposed properly to the jury clearly, her credibility goes down. The judge is aware of this as well. The judge is very aware of this.
I object.
The length of the look before he finally has the courage to object without any basis whatsoever.
Why don't I see it sidebar? Why don't you bring?
And the judge interrupts the entire flow. She has options here. She can say sustained, overruled, and then the answer must come, or a new question. But instead, let's look at this again. This is just so wrong.
Vehicle, that's when you could see what Miss Reed was doing with John O'Keefe, down to the
Little look,
detail
mini
of
look
pulling
there.
her shirt up and pulling his shirt up to try to go skin to skin.
And again, she's not even bothering to answer. She's going to hang with this look at the prosecutor, and I'm not going to answer until you object. He knows that there's nothing to object about, but the pressure from her look to him forces.
I object.
Why don't I see it sidebar? Why don't you bring it to Ms.
And the judge knows that if she's got no other choice but to say overruled, and if she says overruled, McCabe now has to answer the question, which will expose the fact that she's either lying in the first trial or the second trial. Absolutely disgusting behaviour from the judge and the prosecutor, and McCabe herself, who's lying on the stand, in my opinion.
Jackson face.
Okay, well there we are. Let's go back to the testimony. In fact, let's get to the end, because we've all heard it, so we don't need to go over this. At this critical moment, witness McCabe looks to the prosecutor, Brennan, for help. There is absolute non-verbal confession of inability to answer truthfully. Instead of ruling sustained or overruled, Judge Cannone immediately calls for sidebar, bypassing normal procedure to protect the witness, in my opinion. The jury no longer hears what happens. The critical construction, the mathematical impossibility of seeing intimate details in whiteout conditions is never resolved in front of the jury. Essentially, Karen Reed trying to save her loved one by exchanging body heat. This represents a fundamental violation of the defendant's Sixth Amendment right to independent confrontation without interference from the judiciary or the prosecution. So, I've never seen anything like it. My gut feeling, and thank you so much for recommending this case, my gut feeling, based on what I've seen so far, is that we're going to see this sort of behaviour get worse and most likely more blatant. So forgive the transcript errors, forgive the fact that, well, I've got angry, haven't I, basically. We'll leave it there. I wish you all a good night, and we'll get on with the next analysis tomorrow. Okay, have a good night.